Hello, and welcome to Let's Talk Immigration. Today is Wednesday, November 12th, 2025. The first thing I want to talk about today is a group lawsuit that Red Eagle Law is offering for Iranian employment based applicants that are stuck in administrative processing. I'll share my screen here, show you our website, redeaglelaw.com. If you go to the very top where it says group lawsuits, this is the case prospectus. In general, it's a group lawsuit for an Iranian employment-based visa applicants to challenge the travel ban. We'll file the lawsuit on December 5th. Onboarding ends November 26th. This is for employment-based categories like EB1, EB2, EB3. It's not for other categories. You must have attended the interview at least 6 months ago, so on June 8th, 2025 or before. And I've got some disclosures and how to participate. The attorney fees on this one are going to be $4,000 payable as $2,000 on the initial payment and $2,000 deferred until the primary visa applicant is issued the visa. We don't charge extra for derivative spouses or derivative children. They participate for free. So you've got 14 days of onboarding here. There will be, frequently asked questions. We're getting good at this. There's a video I've made more about the lawsuit that in English that'll be published soon, and one in Farsi probably published tomorrow. Okay. What else did I want to talk about? The SEAC website has changed a little bit. That only happens every 20 or 30 years. So let's talk about that. For immigrant visa categories, check my visa status. In the old days, you just put in the case number. Now you have to put in the passport number and the first 5 letters of the surname. But if you've got an old case, like a DS-260 that was completed before January 1st of 2022, you just put in NA, right? Like NA, and that's how you get through that. Let's see what else is going on here. I get a lot of questions about DV 2027, like when's the entry period for DV 2027? If you go to US Visa News, they've made an announcement on November 5th, a week ago, that says, I need to make that bigger. The department is implementing changes to the program, the entry process, and they will announce the start date as soon as practicable. It's an interesting word. I never use that word, but it is a word. So, and they will also announce the date that the DV 2027 results will become available. I think what's going to happen is, like, you know how every year in the past they've done this entry period in like October or November, and then you get the results in May and June. I think what's going to happen is it's going to shift forward several months to where I think the entry period is going to be in the summer, and the results will also come in the summer the following year. But let's just see. That's just me kind of trying to predict the future, which is not always possible. Okay. Kavita says hi. Hi, Kavita. So what else is going on? I put up a tip on Telegram, and I'm going to go find it and tell everybody on the video. So let me see what that tip was. It's been a few days ago. Oh, do I go back to the back of the line when I change my interview location? Because a lot of Iranian visa applicants especially will change their interview location between Abu Dhabi, Ankara, and Yerevan. The answer is no. And to understand why this is true, you have to understand the way the embassy schedules interviews each month and how those slots are filled. The embassy will send capacity lists to the National Visa Center, NVC. For example, they'll say we have room for 60 IRs, 60 FPs, and 30 DVs. Then the embassy fills those slots with the oldest DQ dates, documentarily complete dates, on the list waiting for that embassy, interviews at that embassy. It doesn't matter whether an applicant just changed the interview location of there or not. Or it doesn't matter if they just changed categories from F2A to IR1. There was a period of time for about a year where your place in line waiting for Islamabad as a IR1, you would go back in line every month instead of going forward because more people were skipping in front of you as the F2As changed their categories to IR1s. So that just goes to show you they do these in order of DQ date. They grab the oldest DQ date. All that matters is the DQ date, documentarily qualified date. In other words, you're not put at the back of the line when you change your interview location. You slide into the queue according to your DQ date, compared with everyone else's DQ date in that general visa category that's waiting for an interview at that embassy. I hope that makes sense to everybody. I get asked that question a lot, an awful lot. Okay, what else is going on? Healthcare. Okay, so the Trump administration has sent a memo to the embassies that says that for elderly visa applicants, especially, but all visa applicants, they are for eligibility to the visa, they're going to consider more health conditions, which also include the risk of diabetes associated with obesity. I don't know what this is going to look like. I don't know if they're going to have a scale at the embassy or what's going on, but it's just one more way for the Trump administration to be monsters and to throttle legal immigration. They say that they want like just legal immigration, and then what we see on our side of the fence is policy after policy, cable after memo after proclamation, all designed to limit and prevent legal immigration. So it's probably the biggest driver to irregular immigration is the U.S. government's attempts to sabotage the legal ways to get here. So everybody knows how I feel about that, I guess, right? Okay, Kavita has a question here. After how many months of 221G additional security screening, H-1B stamping in India, is it advisable to file a mandamus lawsuit? Kavita, this is a wonderful question. Okay, we know from a proclamation that we obtained through litigation, we've obtained this proclamation more than once now, actually, that 10% of security advisory opinion requests that are sent to the National Vetting Center take 2 or more years to process. Sometimes it's up to 6. I haven't seen anyone in administrative processing more than 6 years, but I've seen 2 cases like that this year. We don't have that average broken. The State Department didn't share that average broken down per country, which would have been very helpful since the security vetting is different from country to country. I would say that the longest administrative processing average is probably Iranians, which is probably like 18 to 22 months, something like that. And then the average for I think Russians tends to be a year, 14 months. Same with Pakistan. Other countries like Canada, I don't know why people get administrative processing from Canada, but they do. Other countries, usually shorter, but not always. So you said H-1B stamping in India, but I'm not sure if that's your nationality. And I think it's more tied to how long the administrative processing takes is more tied to your nationality than where the interview happened. So I hope that's helpful. Okay. I never answered the question, though. We file mandamus lawsuits for anyone that's faced a delay of 6 months or longer. Just, I want everybody to understand, though, the lawsuit is stronger the longer the delay is. So if you file a mandamus lawsuit after 6 years, extremely strong lawsuit. We're going to get the judge probably to order them to issue the visa if they don't do it before we talk to the judge. So my advice, though, is not wait 6 years. Wait 6 months or longer. You're going to get the first benefit of a mandamus lawsuit no matter what the length of the delay is. And that first benefit is them checking the case, the application, the security advisory opinion, and making sure that it is being processed correctly within existing standards. A lot of times it's not. And the only way to find out is to file a mandamus lawsuit. Okay. Kavita says, where can I find the proclamation you mentioned? I did read the Ready to Go Law website blogs and saw the Carson Wu declarations. So Carson Wu was replaced by Robert Jacob, and Robert Jacob did a version of that law, that declaration in April of 2024. The Carson Wu declarations are from 2023. If you email me, I can send it to you. Curtis@readygolaw.com. I've uploaded it on the Telegram channel, and I've shared that link on Twitter and stuff, but it's hard to find. I don't know. Is it hard to find? What happens? I'm curious. What happens if you Google Robert Jacob declaration? Poor Robert Jacob. All of our lawsuits come up because we file that as a an exhibit to all of our complaints. I bet if you Google, play around in Google, you probably find a link to it, though. But you can email me, Curtis@readygolaw.com. Okay, so it was a pleasure to check in on everyone. I've only got one thing more to say before I get out of here, and that is Ready to Go Law has a TikTok channel, so we can dance, on the ground and over the sea. We're gonna have a lot of fun over on TikTok. Ready to Go Law is, but only if you follow us. So if you have TikTok, follow Ready to Go Law, REDEAGLELAW, for some really great content. It's coming, I promise. Thanks a lot, everybody. Have a good week.